This portion of our training was share things that I've learned in my position working with our investigators on our cases, and then being a liaison to the prosecutors who take our cases to trial, and trying to help on both ends and realize what we can do to help the DAs and make our cases more successful in trial and make it easier on them to take them to trial or get a plea, and what they can do to help us, because the live animal evidence is a unique situation that's not going to be the case in any of their other cases. And I know that prosecutors want to help out the animal care agencies, but they might not realize, they're not, in all their other cases, they don't have, evidence that is the same and changing, like Linda was saying. And so just how we can work together to make these cases go faster and be easier on both sides. This is the disclaimer that I am not giving you legal advice. This is just my experience. Aside from the obvious in a criminal case, this is what DAs know that they need: the specific identification of victim animals. That is a must in these cases. If you have a whole herd of cattle that's bred to look exactly the same, the prosecutor will be sympathetic to that, but they still can't charge without being able to identify a specific victim animal. So you need to help them and find a way to do that. A witness list of everyone who has been involved in that case and how to contact them. And like Linda was saying, a notification of animals that have died in care, because that's not something that happens usually with other types of evidence where it will disappear or change status. So they need to know about that happening. What they don't know that they need, or that I've realized will make their job easier if we provide it, is a timeline. A lot of times these cases take a really long time to happen because we give people a chance to fix it, or they won't let us in the home repeatedly, and we're interviewing the veterinarians and it takes a long period of time. Or we've had an experience before where they did fix it and now they're not fixing it. And just mapping out that whole timeline will help them to know how this started, and what help them with culpability too, showing that they knew they had this resource at this time, and so they should have known at this point too. And laying that all out, because sometimes reports can get really long. You have 10 to 12 page crime reports in these cases, and just giving them, they're so busy, giving them at a glance, this is how this case went down, is helpful. Also, the status of the animals, because that's ever changing, and being able to update them on a regular basis about what the status is of those animals so that they can respond when defense attorneys are contacting them. And continuing discovery, which ties to the changing evidence again, because if it's a medical or a case involving medical issues, initially we'll send in all the materials we have, but then that medical issue is going to resolve or change or become worse. And so I always set a reminder every 2 to 3 weeks, if we have a large case, to send updated discovery to the district attorney, because you don't want them to be in court and have some surprise that's coming up when your veterinarian's on the stand because they thought you told the DA about this already, but you haven't. So just continuing to turn over everything you have as your evidence changes. Notice of the in-care births, because they are going to be used to knowing that their evidence is making more evidence while it's in your custody. So just making them more aware of that, because that's not going to be on their radar. There's so much else that they're worrying about. Assistance with vet records. So you can get the records from the veterinarian that your suspect uses, but in reading over vet records myself, I don't really know what any of that means. It's in their veterinarian, shorthand, and so having a veterinarian call them and explain, or write a report to say what these records are telling you, can be really helpful and save prosecutors a lot of time and make their case stronger. Following up after you submit the case materials to make sure that it's clear what you wanted them to get out of how you presented it to them, who the primary victims are. If you send an Excel spreadsheet of 100 Akitas with varying issues, they're not going to be able to know from that spreadsheet, which are their strongest charges. They're not going to want to charge 100 counts in a case. It's just not realistic. It's not a good use of resources. So help them know which cases are the strongest for them to charge on, and not expect them to be able to dial that in with everything you sent them. And then the laws, we're making an effort to change and improve the laws every year, and prosecutors are responsible for a lot of laws, so it's helpful if you can provide them, or at least I try to provide them with the ones that I think are going to be relevant and helpful to their cases. And Oregon does a good job of escalating sentencing or charging depending on someone's prior record, or if there was a minor there, if they, whatever kind of history they have. And so pointing that out just to make it easier for them can be helpful as well. What DAs don't know that you need, and this is the kitten. You're the kitten asking the DA for something that you need. Because it can be an intimidating situation because you know that they're very busy, and but it's, like I said, working together is better for the animals involved. So I've asked the DAs to request the animal possession ban in the release agreement, so a lot of times you go to arraignment, and then the next proceeding will get set out a few months. So in the interim, you want your suspect not to be able to own animals, and that just makes sense because you're charging them with an animal crime. And so we've been successful in the prosecutors we've worked with adding that in as part of the release agreement. So if there's other animals in the home that might be at risk, but you maybe didn't have probable cause to take at the time, that's a way to try and help out those animals too, and make sure that they don't get more animals while they're waiting to go to trial on the one you seized. Forfeiture of the animals pre and post conviction. There's some, we're going to talk about pre-conviction forfeiture, but sometimes if roadblocks come up with the various ways that you can get ownership of animals before trial, then you do end up having to wait until the case gets adjudicated in trial. And it's good to remind the prosecutor that to include relinquishment or forfeiture of that animal in the sentencing for that case, because sometimes that's not something that goes in every type of sentencing that you're thinking about jail time and probation and all that, but making sure that that gets included, that relinquishment of the animal that you have in custody. And then a 5-year probation period if possible. I know typically it's 2 to 3 years, would be an average probation, supervised or unsupervised, but if you have the 5-year probation period, then that is in line with the possession ban that is automatic in animal cases or animal convictions. And so it's easier to enforce the animal possession ban if the person is on probation and you can check up on them. Something we also ask in sentencing is to write in checks, welfare checks, with reasonable notice or something like that, to make sure that person is in compliance with their possession ban and the other stipulations of their probation. Also, what you don't know you need is a law intern because they will work for free, and they're really eager to get into the animal welfare field, the law students that are interested in this topic, and worth it on both ends, I think, in the DA's office as well as animal control or law enforcement. A lot of you probably don't have time to do a detailed timeline of all your cases, but a law intern would love to do that for you, and knowing that's going to help the case. And for whatever else you need in the DA's office to help go through the massive evidence that is accumulated in an animal case, to have someone that is just there to help you for that is really useful. And I would be glad to help facilitate that program in any way that I can, because I think it would be a good resource for the student and for anyone, any agency that wants to use one. And there's the law school in Eugene, and also in Portland and in Salem, so there's a lot close by. So the remedies for seized animals, this is always the issue. It seems like the primary issue that comes up with animal cases and can get in the way of agencies wanting to take action, because what do we do with all these animals? We get stuck with them for so long. And that's always on our radar too, even with all the resources that we have. It is a drain on an agency. So there are ways to try and address that, and I think we've been looking for a legislative solution going forward about maybe prioritizing cases on the docket where live animals are being held, but we'll see how that goes over. So these are the primary ways that we use to get ownership. So voluntary relinquishment. Once a suspect has a lawyer and has been arraigned and and they decline to release the animals on scene with the officer, then the district attorney can be helpful, because a lot of times the DAs have a relationship with the defense attorneys in their county. They work with them a lot in a lot of different cases and are able to work collaboratively in a lot of cases for the best outcome. And truly signing over the animals, if there's a strong criminal case, the person likely isn't going to be able to possess the animals because they're going to get convicted, most likely. The DA can have that really frank conversation with a defense attorney, who can then talk to their client about signing over the animals and stopping that cost accruing that can then be requested in restitution or in foreclosure or forfeiture hearing. So that's the best way, is to have voluntary relinquishment in the cleanest way. If you have someone who isn't willing to go that route, then there's the pre-conviction forfeiture, which Sarah is very familiar with now. And that's a unique thing for Oregon. It's because it happens before the person has the conviction, and there's case law that I included in the CD that supports that, that it doesn't matter that the criminal case hasn't happened. It's in the interest of these animals to do this pre-conviction. It says that the court shall set a hearing within 14 days, and you have to show probable cause that the crime has occurred. And the court has two options. They can, if they feel like you've met your burden, and the DA can bring a forfeiture hearing, or a lawyer that's representing the animal care agency can as well. But I think it's, in my opinion, it's better for the DA to do the forfeiture hearing versus someone representing the agency, because ultimately it's the DA's criminal case. They're putting evidence on the record that can then be brought up again in the criminal case itself. They have a rapport with the judges know them and trust them, versus an outside lawyer coming in can be a little bit off-putting for the judges. And so I think generally it's good practice to have the prosecutor do it if they can. And so then if the court finds that there's probable cause that the crime occurred, then the court can say these animals are forfeited unless the defendant pays the amount of the bond within 72 hours. And the bond is the cost to the agency for the animal's care up until through when they think trial is going to happen. So up until the forfeiture hearing, and then beyond that to whenever they think trial will happen. So it can be a lot of money in these cases with a lot of animals. But a judge can also has the right to waive the bond for a good cause, so that's always a risk you take. But it's good because it can happen quickly. It says it should happen within 14 days of the petition being filed. There's clear due process and a clear transfer of the animals. Potential drawbacks of it is that it only forfeits the rights of the people who are part of the proceeding. And so if you think there are some third-party issues, that can make it a little bit more complicated of a remedy. The petition can only be filed after the criminal charges have been filed. And so if you are working in a county that is very behind on their filing, then you're waiting for that to happen before you can start the forfeiture proceeding, which can delay that. It says sometimes only for the animals charged on. The law, as it's written right now, can be considered ambiguous about that point, and some judges have been convinced that it is only for the animals charged on, but you don't want to put your DA in a position to be charging 100 counts in a case, like I was saying before. So this session, we're proposing a bill that will change that to be really clear that it's every animal that was seized as part of that criminal episode, every victim animal that was seized under that statute, but it doesn't have to be associated with this specific charge. And then this is something that can happen as well, and happened to us in the Akita case, that we had to go through each animal we seized, prove probable cause for neglect on that animal, and you kind of, as a lawyer in a forfeiture hearing, you're walking the line of not wanting to put on your whole criminal case and have them see all the evidence that you have and interview, basically depose all of your witnesses for trial ahead of time. So we put on the evidence that we thought met our burden of probable cause, and then I suspect that the judge maybe was sympathetic to the defendant, so she said, you met the burden on all of them except for these 8 or 4. And So then the DA had to drop the charges associated with those 4 dogs because there was a finding by a judge that we didn't have probable cause to seize them in the first place. And so, so then we lost charges on those animals. So that can happen, but that's fairly rare. Usually when you're going into a forfeiture hearing, you have solid evidence and you're going to meet the burden of probable cause because it's so much lower than you would for reasonable doubt. And then, like I said, the judge can waive the bond. Lien foreclosure is another way of getting ownership of seized animals. I think county council was here at one point. But the animal care agency can do this and county council can do this. I don't think it would be proper for the district attorney to do it. But this sort of takes advantage of animals as property. A lot of times we have ethical discussions about the dog being treated the same as a couch or something in the law, but this takes advantage of that status because it calls them property that you can foreclose on. If you seize an animal under that search warrant statute that I mentioned earlier, then after 60 days, there's a lien that attaches for the cost that the animal care agency has put into caring for those animals. And on the 60th day, the lien attaches and you can give 30 days notice to anyone. You put an ad in the newspaper, you post it at the courthouse, you post it where you seize the animals, just notice everywhere possible that you're going to foreclose on these animals in 30 days on the courthouse steps. And then you go there to the courthouse on that day and you read it up just like you're foreclosing on a house or something like that, and you offer to take bids, first call for bids, and usually the lien amount is in the thousands of dollars, and you're selling the animals, usually multiple animals in one lot for cash on that day. And I have yet to have someone show up and bid over our lien amount. So if no one shows up to bid, then ownership reverts to the agency that's put that money, who has the lien. And then you send in that accounting and you own the property. So this is a good remedy because it extinguishes everyone's ownership interest in the animal. They built in a due process component a few years ago, so when you seize the animals, you let the person know these are the remedies that we can pursue, foreclosure and forfeiture, and they have, I think it's 30 days to petition the court to get in front of a judge before you can foreclose. So that was added in there as your opportunity, as your due process. But if you don't petition the court in that time frame, that's considered a waiver of that, and then this goes forward in this way. It's a non-judicial proceeding, and you're not going to potentially impact the criminal case with this one like you can with forfeiture. It applies to all the animals seized. It doesn't have that hiccup that forfeiture has that hopefully we're going to fix. Unjust enrichment is something that is an option for, again, it would be county council. If someone is demanding their animals back and you don't want to give them back, you could have a cause of action called unjust enrichment. Because this is a good example of it, because this is how we got the dog in and this is how we would be giving it back. So there's a civil cause of action that basically says if we give the dog back to you in perfect condition, you were unjustly enriched because you didn't have to pay and do the time and all this to make it a better piece of property than it was when we got it. So that's another option to use. There's some defense strategies that come up in the context of these. There's been an evidence hold order when we've gotten ownership of the animals and they don't want us to adopt out the animals even though we own them now. And a counter to that, it's a little controversial, but that the animal care agency isn't a party to the criminal suit, and therefore the trial court, the argument is, does not have jurisdiction to issue an order dictating what you do. That can piss off the judges, so that's something that you wouldn't want to do unless, without talking to your DA and considering what the ramifications of that would be. But it's something that you can throw up in defense of that. Also, that the live animals at this point are not evidence of the crime that happened initially, and so holding them doesn't preserve any sort of evidence that they would need, and that you can track them and make them available for court. If you adopt them out, it doesn't mean that they're gone away and they can't ever come back. If they really want to bring the animal into court, you'll have the address of the adopter and they can subpoena that. that way. You don't need to hold them at our facility. There's also a motion to compel the return of evidence that the defense can do. The counter to that is that lien that the Animal Care Agency has in place. So aside from the criminal case, we have this separate lien, and so we're not going to return it until our lien has been met, our cost of care. Also, and especially if that order in the release agreement says that the animal or the defendant can't have animals pending trial, then you can say we're not going to return the evidence because the animal is now a contraband in the hands of the defendant. So you should be able to defeat the motion to compel on that argument. This is notable case law in Oregon that's included in the CD that some of you might be familiar with, but the Nix case, which got overturned on jurisdiction, but the Hess case is going to stand for it. Also that animals are victims for charging purposes. So it's not a single criminal episode and counting as one count. In the hoarding case, for example, each victim animal in that case is a separate charge, and they're each separate criminal incidents as related to the animal. Newcomb is the one I mentioned earlier about the search inside of the animal being a secondary search to the seizing of the animal itself. And that was basically overturned at the Supreme Court level, saying that, especially if you're medically treating the animal, that's not a secondary search, so you should go ahead and treat the animal medically. Fessenden is about a horse, but it talks about exigency and being able to seize an animal based on exigency. And then Brandstetter goes to the pre-conviction forfeiture, and the burden of proof there is supportive. So I encourage you to check those out. But yeah, we're always happy to talk through issues with you and what's happening in your case, and if we've encountered it before and how we've worked around that issue. Also, for those of you who haven't heard of Jake Kamens, he's the special prosecutor for animal crimes in Oregon. He's a good resource for district attorneys' offices, but also for law enforcement as well. He's been in that position about 3 years, and he can be specially appointed in any county to take on animal cases because they do take up a lot of time and resources, and so he can offset that for the district attorney's offices when they need. Questions about any of that? Yeah.
So a lot of the material that you cover talks about animals that are seized via a warrant, but if the law officers on scene invoke the exigency or exigent circumstances, then do all of those forfeiture, lien foreclosure, do all those processes still apply?
Yeah, so it's always helpful to have, the warrant is always the safest and strongest route to go because it's mentioned in those statutes, but if you're seizing an animal on a valid exception to the warrant, which that is, then it would still apply.
Okay, thank you.